Joe, I believe you're muted. We're not hearing you speak.
Okay, got it. So guys, I think I'm unmuted now. Now you're unmuted, but that's okay. Actually, we'll go from Ms. White to Ms. Harrison. Beth, your opening remarks, please.
Hello, everyone. My name is Beth Harrison. I'm one of the supervising attorneys in the Housing Law Unit at Legal Aid, and thank you so much to the Office of Tenant Advocate and the Office of Attorney General for putting on this event. And both of those offices are great partners with Legal Aid in the work that we're doing. And I'll just say a few things. I want to say something about kind of what's coming to add on to what Jason Downs has already shared. And just a little bit overview of what the council's done, but then of course what Legal Aid and other providers are doing. So in terms of what's coming, there's actually a new tool that was put out this week based on a census survey that's been happening every week. And that tool, the name of it is Stout. I can put a link in the chat box in a few minutes, is predicting there will be over 30,000 eviction cases now they are saying in the next 4 months. Whether eviction cases can be filed in the next 4 months, we'll talk about. And it's based on the census survey that for DC shows about 25% of residents are expressing that they have had trouble paying the rent or will have trouble paying the rent. We expect that number is probably a lot higher for, of course, households with lower incomes, households headed by people of color, households with undocumented workers who have not been able to qualify for unemployment and so forth. And 50% of households in DC report having some loss of income so far in the pandemic. And I haven't looked at the latest numbers, but I know there have been over 100,000 residents apply for unemployment. And just bearing in mind undocumented folks and some workers who have not had sufficient work history don't qualify for unemployment and may not have even applied. So that's an undercount as well. So the bottom line is there is a serious issue with tenants not being able to pay the rent and facing eviction. And I think the concern about tens of thousands of cases being filed at some point is certainly warranted. In a normal year at this point, we would have seen about 15 to 20,000 cases filed. Only 8,000 have been filed because of the different laws preventing new cases from being filed. And so I think we have at least 10,000 cases that are out there in a normal year and probably many more because of the current situation. And what I will say just for opening remarks for what the council has done is we have worked, Legal Aid has worked, OTA and others have worked with the council to get some very strong tenant protections in place, especially compared to other places in the nation. And we appreciate that. But really, it is just delaying. It is not solving the problem. Tenant payment plans, for example, are a good protection, but ultimately tenants need financial assistance to be able to pay back rent if that is what is going to need to happen. And so that is what is driving, for example, the tenant movement calling for canceling of rent is the real need that is out there. And, there are some new rental assistance resources, but even today, the council is looking at trying to make $18 million in cuts to balance the budget and recognizing that probably, either new tax revenue or more cuts will have to be made in the fall. So what is Legal Aid doing? We are working with 5 other organizations that receive eviction defense funding through the City Council. Bread for the City, the DC Bar Pro Bono Center, Legal Counsel for the Elderly, the Neighborhood Legal Services Program, and Rising for Justice. We have a centralized intake number. I'm going to put that in the chat box, but also say it out loud right now, which is 202-780-2575. That is the Landlord Tenant Legal Assistance Network. And we are offering assistance to tenants and to small landlords who do not have attorneys. What we're seeing is a lot of tenants who are talking about not being able to pay and fear eviction, but also illegal conduct, lockouts, harassment by landlords. And we appreciate the partnership we have with the Office of the Attorney General to refer cases there for them to respond, as Jason Downs was saying. And that's been a great partnership and has resulted in many more tenants in that harassment stopping. But we know there are many tenants facing it who have not reached out yet and are in fear. Legal Aid is on the Landlord Tenant Court Working Group. So we are working with the court And we and the other providers are monitoring the court hearings that have started so that we can offer tenants services on the spot during the hearings and then following up. We have sent outreach letters to tenants with pending court cases. And we are also hoping to have a coordinated effort for cases that were filed from March 11th on, which are subject to dismissal under local law and many of them under federal law as well, so that we will be able to help argue to the court on behalf. There are about 1,700, almost 1,800 of those cases, to have a coordinated argument to the court about why all of those cases should be dismissed, even if we don't individually represent all of those tenants. And I am going to pause there, but I'm looking forward to this program and answering questions and having a discussion today. Thank you.
Thank you, Beth. And am I back on, Stephen? Okay. Thank you, Beth. And now we'll turn to Eddie Cordone. Eddie?
Yes, my name is Edward Cordone. I would also like to extend my thanks to OTA and OAG for putting this forum together, which I think is important for anybody that's involved in the landlord-tenant world, so to speak, in the district, both landlords, tenants, and all the organizations, attorneys' offices, and the court. This is a very informational and helpful to all the stakeholders regarding landlord-tenant issues. And the COVID pandemic, my general overview, I've practiced in landlord-tenant court for the past 20 years. We represent predominantly landlords, but we also do tenant representation as well in all kinds of eviction cases, both rent, lease violation, foreclosed homeowners, etc. And my overview of the COVID situation, both in general and also locally with the district, is as follows. Many states in the country right now, their courts are opened, eviction cases are being filed, and in some states, I believe Texas is one, there is no eviction moratorium, and many people are getting evicted in many other states in the country because there are no moratoriums and filings are up due to the financial crisis that the COVID pandemic has caused many people. However, in the district, the DC City Council, and also to a little bit more of a limited extent, the federal government under the CARES Act, the DC government has put protections in place here, which give tenants an enormous amount of protection because the law currently prohibits any landlord from filing a court case until 60 days after the mayor lifts the public health emergency. That public health emergency was due to expire this Friday on the 24th. However, Mayor Bowser has extended that to October 9th, which means no new eviction cases can be filed until December 9th, assuming the mayor lifts the public health emergency in October. And what that means from an eviction standpoint is that cases filed in December probably will not get hearing dates until after the first of the year, which means those cases have to go to court. And in any of those new cases which result in judgments and evictions for whatever reason, those evictions likely wouldn't happen until next March or April. The information that's been out informally with the court also is that when the court reopens, landlord-tenant court is the busiest branch of the Superior Court. It basically handles about an average of 210 cases a day. And generally when court cases are filed, those court dates, the first court date in those cases is generally about 30 days away and has been for 20 years. However, the information that we have so far, again, informally, is that when the court reopens for safety reasons, they're not going to be able to allow that many people into the courtroom at one time. And so the information that we have is that the court will probably reduce the calendar. The reason that's important for tenants is because even though there may be a wave of new cases filed in December, should that be the time when cases can be filed, those cases are all not going to come to court in 30 days. Those court dates will probably be spread out between 30 and 90 days away, and that will be the new norm. I say that in the following context, that although there may be a wave of filings that may come, I don't think that there's going to be a wave of evictions in the district because of the protections that are currently in place. And when we restart the process again with the court, those cases are going to be spread out much thinner over longer periods of time. So there may be a little buffer here that tenants have an advantage of that other tenants don't have in other states around the country, which are currently filing and actually evicting people, which we're not doing here. My understanding is that last year, I believe the amount of total cases filed in landlord-tenant court was about 30,000 cases, give or take 1,000. And although there's been no cases, there may be no cases filed for 8 to 10 months, given the DC law at the moment. So even though there might be a rash of cases filed in December, those are going to be spread out over time. And at the end of the day, because of the amount of cases that can be calendared and are limited, that amount should probably remain the same, if not go down. And again, there may be more cases filed, but they're going to be spread out over longer periods of time. And the new law also mandates landlords now to go into payment agreements with tenants before they can go to court. Many landlords that I represent, and I predominantly represent single landlords and small management companies, are ready, willing, and able to try to do payment agreements with tenants if possible, because this has financially impacted landlords as well, because that rent money isn't solely used to pay the mortgage. It's also used to pay property taxes, utilities, repairs, payroll, and the like. So I believe both landlords and tenants in some respect are in the same boat and need each other to try to work through this crisis as best as possible. If there were a lot of people out there who were working and didn't have financial issues, a landlord might say, I might like to get another tenant in my unit, but the pool of people out there is been highly affected by COVID. And chances are that your next potential tenant may be somebody who's been financially impacted by COVID as well. So it may be in those circumstances that it's more in your interest to work with the tenant that you have to try to get through this together until all of this has passed. That is my very long, hopefully short overview of where I am on this, as well as in respect to a landlord's perspective.
Great, thank you, Eddie. That was great. And Jen, your opening remarks.
Hi, everybody. I'm Jen Berger. I am chief of the social justice section of the public advocacy division of the Office of the Attorney General. To give you a little insight into what PAD does, we are an affirmative litigation arm of the Office of Attorney General, and we have a consumer protection team, a team that deals with nonprofit related issues, and the social justice section addresses housing enforcement, environmental justice, and workers' rights issues, which fit together nicely to more holistically ensure equal access to a safe environment, to sick leave, to pay when there are wage theft situations. And the idea is to ensure that people have the income and the environment to live safely and be healthy. In terms of the housing enforcement work that we do to help tenants, if you check out the Attorney General's website, there are a series of press releases that talk about the work that we do. And recently, Jason was referring to a large-scale building in Southeast DC that we assisted in accessing repairs and accessing restitution for the repair issues that they suffered. And then separately, we help people live in safe environments by ensuring that we address violence, criminal activity, firearm activity, drug-related activity in housing. In terms of COVID-related work, about 3 weeks into when I started at OAG, the public health emergency began. And before that, I had a deep history in working with tenants. And one of the largest issues that arose immediately was that after the COVID legislation came out, that illegal rent increases were at least attempted at being implemented. And then soon after that, wrongful evictions were being threatened as a way of trying to circumvent the fact that courts were closed. And this deeply, and I'll talk about this in more detail once the questions come, this deeply affected in the immigrant community. And there was a New York Times article that discusses that you could Google, that talks about the plight of people who doubly fear being deported, at the same time are being threatened with eviction, and then also during a pandemic. In terms of consumer-related work that we do at the Attorney General's office, that interfaces directly with, sorry, no. That interfaces directly with, that's not the part they're supposed to be barking. We're supposed to be talking about noise complaints a little later. So the consumer work interfaces directly with the pattern and practice issues. So when there are large patterns and practices of landlords who are not repairing properties, then we can harness the consumer protection statutes to advocate for tenants. And then separately, safety issues that arise in the workplace, we address that as well. We're trying to more seamlessly help people live safely, be able to still earn the money necessary to address their basic needs. And I'm going to put myself on mute so you don't have to hear that.
Thank you very much, Jennifer. That was great. And Cristobal, your opening remarks, please.
Hi, good afternoon. I'm Cristobal Puig, Legislative Counsel for the Office of the Tenant Advocate. The Office of the Tenant Advocate is an independent DC government agency that provides legal advice and other tenant support services, policy advocacy, and education and community outreach services as well. During the public health emergency, we've been working hard to try to prevent evictions and keep people in their homes. We're getting, for example, a lot of intake cases, especially about the rental payment plans from folks who are worried about possibly being evicted. On the policy front, OTA is working closely with the DC Council and with our community advocate partners on emergency legislation. And the Chief Tenant Advocate Shreve is now advocating for the extension of the eviction moratorium. Also, for scheduled evictions, once things get back up and running, we're sending out rapid response letters for affected households so that they know their rights, and most importantly, so that they know that the Office of the Tenant Advocate is here to help.
Wonderful. Thank you very much, Cristobal. So we've organized the questions into about 4 categories. The first group of questions is what tenants need to know about rights and resources under the emergency legislation. We've covered that a little bit in the opening remarks, but I'm going to begin with Cristobal to explain so we understand the sort of trilemma, one might say, of the eviction moratorium under DC law, and then also add to that what do tenants need to know about the federal law with regard to the eviction moratorium.
Okay, so let's review the applicable public health emergency laws that protect the district's tenants from eviction. In DC, the DC Council approved the Coronavirus Support Emergency Amendment Act of 2020 that provides specific tenant protections. In the District of Columbia, a tenant cannot be evicted during the public health emergency. Eviction actions cannot be filed in court during the public health emergency plus 60 days thereafter, and eviction summons may not be served during the public health emergency. So what does this mean in practice? This means that for new evictions, the earliest that they can be filed in court will be on the 61st day after the public health emergency ends. And for evictions that are already in the pipeline, assuming there's already been a hearing and an order in favor of the landlord, then DC courts and the United States Marshal Service are requiring that landlords comply anew with the statutory requirements of the Eviction with Dignity Act of 2018 that provides 21 days notice of the date the eviction will be executed. I'll note that OTA advocated in favor of the Eviction with Dignity Amendment Act back in 2018. Additionally, here in DC, in the context of the tenant payment plans, once a payment plan has been established between a landlord and the tenant, as long as that tenant stays current on the monthly payments, a landlord is prohibited from filing any collection or eviction lawsuits for the non-payment of rent. So those are the DC specific laws. Now let's just take a quick look at the federal So there's roughly 12.3 million rental units in federally financed properties. So on March 27th, the Congress enacted the Coronavirus Aid, Relief, and Economic Security Act, better known as the CARES Act. The CARES Act provides a 120-day temporary moratorium on residential eviction filings, during which landlords may not initiate eviction actions for the non-payment of rent or for the non-payment of other fees or charges, and landlords may not charge tenants any fees, penalties, or charges related to the non-payment of rent. Landlords are also prohibited from issuing notices to vacate during the moratorium period, and they're required to provide tenants with at least 30 days notice before they must vacate the property. So who is protected by the 120-day CARES Act moratorium? These protections apply to all tenants in the District of Columbia that live in an accommodation that receives a federal subsidy or where the landlord has a federally backed mortgage. How long is this moratorium enforced for? Well, the eviction moratorium took effect on March 27th on the enactment of the CARES Act, and it lasts for 120 days, expiring on July 25th. Now,
Okay.
Sorry.
Okay, no, that's great. And that was about the eviction moratoriums, and you gave a little more information, which is great. Thank you, Cristobal. We want to identify also other protections under DC emergency laws to help tenants pay the rent and avoid eviction. And we've touched on those as well, but I wonder if Beth and Eddie can perhaps tackle that. Just the headlines will be fine. And I'm going to remind everybody that Stephen, when he sent the link, also sent the OTA tenant rights and resources document, which is newly updated. And please study that for details. Let us know if you have questions. But Beth and Eddie, do you want to tackle that one beyond moratoriums? What are the key things about the DC emergency measures that tenants need to know and housing providers?
So perhaps we should talk about tenant payment plans for a minute. And I know there's some questions coming up in the chat about that. And so the DC Council has enacted an emergency law that requires landlords to set up a tenant payment plan program. It has to be in place during the public health emergency and for 1 year after, and it has to cover rent and other amounts that are due from a tenant under the lease for that same period of time. So the public health emergency and 1 year after. There was a question in the chat box about kind of what are the required terms for the agreements. So it's not very specific, but the law does say the minimum repayment term is 1 year, and there are supposed to be equal monthly installments and no requirement for lump sum payments. And then another question was asked about, well, what happens if a landlord isn't offering a tenant payment plan? And the law does say a landlord cannot sue for eviction or to collect the money otherwise. So for example, if they were to file a small claims case just to get the money instead of eviction, they cannot do those things unless they set up this tenant payment plan program and they approve any eligible tenants. And then an important detail is who is an eligible tenant. And so an eligible tenant is someone who directly or indirectly has been impacted, has a financial hardship due to the pandemic. And the landlord has to set up an application form and can ask for some documentation of that, so of the tenant's financial hardship. And the tenant has to notify the landlord that they have some inability to pay rent because of the pandemic. I will just say, if I can, just a couple of things about how we think that will play out. I think even though this has to last for a full year, whenever landlords can start filing eviction cases, a lot of tenants are going to be in the position of having to choose whether to enter a tenant payment plan if they can or to face eviction. So right now, because tenants cannot be sued for eviction, they don't necessarily have to make that choice. And our general advice to tenants is if you're not ready to enter a tenant payment plan and your landlord is offering one, tell them that you're not ready yet. Tell them I'm still trying to figure out my income situation, my employment situation, and you certainly should not feel pressure to do so. If you want to enter one and the landlord's not offering them, that's a slightly different problem, of course. But I think at some point, landlords will be able to start filing cases, and tenants, if they want to take advantage of this law, will have to make that choice. And I will say, I understand Eddie's comments about, you know, the court process is going to be slow and actual evictions may be slow. I don't think that diminishes the point that many, many eviction cases will be filed. And what happens with those cases, I think, is largely going to depend on, is rent canceled or is other rental assistance put in place so that tenants who have a financial need for assistance get it. And I feel like I should stop talking, even though there are a few other provisions. I'll see if Eddie wants to jump in on some of the other provisions, or throw it back to me, Eddie, if you want to, but I'm going to pause.
Eddie, you're up.
Thank you, Beth. I believe Beth more than adequately covered the tenant payment plan requirements under the law, with the landlord now being obligated to offer a payment plan program to its tenants. If somebody makes a request to get a payment plan, an application is given, and if they qualify by being able to demonstrate or document indirectly or directly some sort of financial hardship related to COVID, the landlord is required to approve that plan and give them a payment plan. I will say that the amount of cases that are being filed, one thing I can say in response to Beth's comment, although there may be a lot of cases that are going to be filed, as I indicated earlier, they'll be spread out, but because there's going to be a long gap between those cases getting filed, the hope and expectation, I would think, would, for both sides, would be that by the time that we get to that point, maybe this COVID has gone away or subsided to a point where people are working again and able to make payments, and those cases would be resolved before they're even filed. I mean, I currently, as a matter of practice for 20 years, there are programs out there. Beth has much more knowledge about this than I, but I can tell you this: the DC Emergency Rental Assistance Program, better known as ERAP, is still operating now. They currently, when I'm in court and court is in session, I always bring a stack of ERAP information sheets with me to give to tenants in an effort to provide them information that they can get financial assistance with. ERAP's general rule is that a tenant may get money from their program once every 12 months. ERAP will generally pay a maximum of $6,000 if the tenant has a disability, a minor child, or an elderly person living in the unit. If they don't have one of those three things, ERAP will pay up to $4,250. I am told by Susan Jacobs a couple of weeks ago, who is a supervisor at Housing Counseling Services, that they also now have an additional program with money from the federal government in addition to their own programs. So there are resources out there. And in addition to those government agencies or government-sponsored agencies, I oftentimes will refer people to many churches in the District of Columbia provide rental assistance to people. I know Shiloh Baptist Church for years has done that. You don't need to be a member of the congregation to apply. Their paperwork is very minimal compared to ERAP. However, their restriction is $1,000 maximum, but there are many churches out there that provide rental assistance to tenants as well. And if people are stuck in that hump, or in that bubble where they're out of work for a couple of months and may only be behind by a month or two, you may want to explore getting rental assistance from churches that provide it in addition to ERAP. The money is out there, and my understanding is they're taking applications, although remotely, but the money is out there for people should they need assistance in addition to whatever they can do on their own.
Great. Thanks, Eddie. And I am going to, on Beth's behalf, mention, she might have these in mind, that also there's a freeze on rent increases for the duration of the public health emergency. Landlord has to provide a new notice of rent increase, so that's 30 additional days before any rent increase has to be paid. Also, am I okay? Steve? And then also on late fees, the landlord cannot charge late fees during the public health emergency. For amenity fees, if the unit is under rent control, and if the amenity fee is charged over and above the normal amount of rent, and it's not a part of the rent, then those can't be charged either. I don't know. I want to talk a little more about the financial assistance that's available. But Beth, does that cover your additional items?
Sorry, I was flipping to my list and then needed to unmute myself. I apologize if you mentioned these because you said a lot of things quickly and my brain is only 50% functional right now. Their deadlines for tenants under TOPA are on hold. Deadlines for tenants under the Rental Housing Act are on hold, and I think we're going to end up having a legal debate about what that means, because I certainly think it means that tenants who get lease violation 30-day notices right now, that their deadline to fix the problem is told, and Eddie can say or not say if he agrees or disagrees. That's up to him. But I think there are some legal questions that are unresolved that we'll have to deal with on the back end. The council also put some language in the law about serving eviction complaints that I know landlords and tenants are going to disagree about what it means. And I think and then we haven't talked about the federal law, but I think we're going to. So I'm not going to, you're focused on local, and I'm going to pause again.
Okay. Well, I'm going to ask Cristobal to expand on what Eddie was saying about ERAP. And if you can go, I'll ask a twofold question. Cristobal, just the headlines in terms of what's available from the federal government or anything that has not been mentioned about DC government. And then we're going to ask Beth and Eddie to talk about sort of the value added for district residents in terms of federal protections overall, over and above district. So Cristobal.
Department of Housing and Urban Development, HUD. So, for example, the COVID-19 Housing Assistance Program, CHAP, which I believe was mentioned in the chat, received approximately $6.3 million to provide up to 3 months of rent arrears for low-income renters. DHCD will direct approximately $2 million to 3 local nonprofit organizations to administer that relief, and these organizations are the Housing Counseling Services, Greater Washington Urban League, and the United Planning Organization. The COVID-19 tenant-based rental assistance also received $1.5 million, and the district received approximately $23 million in emergency solution grants that will be administered by the Department of Human Services. So these funds have also been used for other support services for district residents, including housing counseling and food assistance programs and other essential needs for district residents.
I hope that's a good question. Beth and Eddie in particular, because you're practitioners, can you sort of give us a solid sense of the federal protections, aside from the financial resources, but you can mention those too, that is really value added for district tenants, given what the district government is providing for its renter population. Beth, do you want to start?
Sure. So the federal government under the CARES Act also created an eviction moratorium, and it applies to essentially any federally connected property. So any property with a federal mortgage, with federal housing assistance, which we are not quite sure, but we think might cover something like 40 to 50% of eviction cases that are filed during normal times. I can say Legal Aid has done an audit of all the cases that were filed. That moratorium started on March 27th. Legal Aid has done an audit of all the cases filed since then, and it looks like at least a third of the cases filed were filed in violation of federal law. It's about 300 cases out of roughly close to 900 cases filed during that time period. So certainly landlords have not completely complied with that law. I will say, of course, information changes very rapidly, so we understand. But there are a number of cases filed weeks after that moratorium was in place that are illegal filings. But the local law was put in place on May 13th and is retroactive back to March 11th and says that all eviction cases had to stop as of March 11th. And so these are the 1,700 cases roughly that I referred to that were filed between March 11th and now. We have a legal issue there because laws usually aren't retroactive. So it's unusual for the council to pass a law and say, hey, that thing you did last month or last week, it's illegal. And I know you already did it, but it's illegal. But we're in an emergency. And so the council can and has made the judgment that the law should be retroactive. Now, landlords may say essentially that's unfair to the point that it violates my constitutional rights as a landlord. And I will let Eddie speak to that, but we are expecting there will be some challenges to that. And so when I said at the beginning, all the 6 eviction legal service providers that I mentioned are going to coordinate on that, we are hoping to work with the court so that we can present the best legal arguments to support the law against what the landlord's attorneys will, potentially present as reasons the law should not be applied retroactively. And it is worth knowing that if constitutional arguments are raised, that the court rules say that then the Office of Attorney General will have to be notified and given an opportunity to come into court and defend the local law.
Great, thanks. Eddie, do you want to follow up on that?
Yes. One thing I will say in general, and I don't think Beth would disagree with me, is that both the federal legislation and the local legislation, because these were bills that were emergency in nature, they didn't go through the same vetting and input, public hearings, congressional review, et cetera, that normal laws would go through before they're passed. As a result, a lot of what has been passed has created a lot of legal issues, which the court is trying to work through now, because some of it is unclear. Some of what the feds did conflict with DC law, and the only way that these issues are going to be resolved is when they come up in court. The Federal CARES Act was passed on March 27th. It's an 852-page bill. In that bill, there's about 4 pages that relate to evictions. Beth is correct. The protection that the federal law provides to DC residents now is the following: that for 120 days, there is a moratorium on landlords initiating any actions based on non-payment of rent against any tenant that either gets a federal rent subsidy or resides in the building that has a federally backed, insured, or guaranteed mortgage. That moratorium is scheduled to expire Saturday. And one of the ways it conflicts with DC law is that DC law doesn't require a notice to be sent if it's waived in the lease when it applies to rent situations. The federal statute appears to say that you must issue the notice once the moratorium expires. The House of Representatives, the U.S. House of Representatives, has passed the HEROES Act. Currently, the Senate and the House of Representatives are going back and forth to try to get a third stimulus bill passed. In that bill, those eviction moratoriums may be extended, they may expire. If they expire, the only thing that would allow a landlord to do on Monday morning would be to issue a 30-day notice for non-payment of rent. When that notice expires, DC law then comes into play because the landlord is unable to file a case based on expiration of that notice until December 9th, which is currently the date, which is 61 days after the October 9th public health emergency. But again, that's assuming that the mayor lifts it at that point, which she may or may not do, depending on what the situation is with the pandemic at that point. It may be better, it may be the same, it may be worse, and that public health emergency may be extended. The DC law also created a couple of issues that eventually the courts are going to respond and resolve. Beth has touched on one of them, which is the cases that were filed after March 11th, because the DC City Council passed their original COVID emergency legislation on March 11th. They then subsequently updated it 3 times, with the final update being May 13th. On that date, that's the date in which they amended the legislation to mandate the payment plans, but also the prohibition on the filing of cases. But they also made that bill applicable back to March 11th. That bill has now expired. It's only emergency legislation. It's good for 90 days. That bill expired June 8th, but there's another bill that was signed on June 8th that took effect June 9th, which is basically another 90-day emergency bill, which is pretty much exactly the same as the prior one, while the DC City Council is awaiting congressional approval on the temporary legislation, which will be in place longer. So that's basically the protections that both laws provide. And again, there are, I think, as far as I know, and everything I've read and everything I've seen, there's more protections provided here related to landlord-tenant evictions than there are pretty much anywhere in the country. And hopefully, at some point, this all gets resolved in a way that is satisfactory to everybody involved, because it's not going to be easy for landlords. It's certainly not going to be easy for tenants, and it's not going to be easy for the court. But that's where we are at this point. There are protections, but there are conflicts which the courts are going to have to resolve, because a lot of this legislation was written very quickly, and it created as many issues as it resolved. But go ahead. I'm done. Thank you.
Thank you very much, Eddie. So we're going to be turning to Lachey in just a minute for the court's perspective. But first, I want to ask Jennifer, if you're a district tenant who has a disability, who's a member of the immigrant community, perhaps you're in the rapid rehousing program, you are essentially an especially vulnerable tenant. What do those tenants need to know?
Those tenants should know, Joel, that they are protected under the Local Human Rights Act and the Federal Fair Housing Act. And I also want to make sure they know, and I'll put the information in the chat box, that the Civil Rights section of the Public Integrity Division of the Attorney General's office is happy to hear about complaints like that, and they are ready to launch on situations where there is a pattern and practice of discriminatory behavior on the part of housing providers.
Terrific. Thank you, Jennifer. So Lachey, you've been kind of quiet so far, so we're going to put you on the hot seat. I hope that's okay.
Sure, go ahead.
Good. So first, I wanted to ask some data questions. Beth and Eddie covered sort of the point of comparison to where we would usually be in terms of the number of eviction filings. And the number I have is, Beth mentioned 8,000 filings so far this year, as opposed to the normal 15 to 20,000. Let's see. So if that, confirm or correct that that's the court's perspective, what that number is. But also talk about the number of filings at landlord and tenant after the public health emergency started, and presumably should have dropped to zero. But the number of filings that have happened since the council's prohibition on such filings took effect, and then also if you can break that down by non-payment of rent claims versus all others, including lease violations, personal use of occupancy, all the other bases for eviction, we appreciate that. So just whatever information you think we need to know that the court has its hands on.
Okay, so thank you. First off, I want to be transparent and share that I do not have the numbers based on the complaint type. What I can tell you is there have been slightly under 3,000 cases filed since March 11 during the pandemic, since we've gone fully remote. Keep in mind that part of that month we were on site, and I believe we resumed remote operations on or around March 17th, March 18th. But since the public health emergency took place, there have been approximately 2,700 cases filed during the moratorium. With respect to the CARES Act and some of the other legislation that both Beth and Eddie, have discussed, and recognizing that there are some laws that may contradict each other, the court's position is that they will address those matters on a case-by-case basis. They are the presiding judge, which is Judge Cordero, and the deputy presiding judge, which is Judge Epstein, Anthony Epstein. They will and we're having ongoing discussions about how court will operate, and they will do what they need to do on a case-by-case basis and based on the merits presented during those hearings, which are being held remote right now. I'll also have the floor and share information about how we've been operating thus far. And if I could get Joel to bring up the complaint form 1B, because that is the complaint type that we are addressing right now during the public health emergency, when we have contact information for both the plaintiff and the defendant. We have changed our hearing notices as well. So let me back up for just a second. And if you would scroll down some, I wanted to, let me see, rather than Joe, cancel that scrolling through. What I'll say about this complaint type is that it doesn't focus on non-payment of rent. It addresses other types of lease violations other than non-payment of rent. And this is how the court is triaging the type of complaints that we're receiving during the public health emergency. And we have already began sending notices to all parties in these cases for remote hearings and letting them know how to dial in based on the technology that they have. If they don't have devices that allow them to participate in a video call, then we are also providing them with the audio number only so that they can fully participate. And we have been partnering with the Landlord Tenant Network Association. And so we've also included their contact information so that tenants know not to wait until the last minute. The earlier that they can engage to seek legal resources, the better it is for them to protect their rights and ensure that they take advantage of the resources and information available to them. And that information on our notices is available in both English and in Spanish. I will also say that a number of the panel members today, including Beth and Mr. Cordone, participate on the Landlord and Tenant Civil Work Group meeting with the Landlord and Tenant Branch monthly. It includes a number of other stakeholders as well. And through that forum, we have been working together to address many of the issues and concerns and different perspectives that the advocates for the tenants have versus those of the landlord. And we will continue to share and collaborate and share information accordingly. What I'll also say is in speaking about additional steps that we've done to ensure access to justice and provide resources to tenants during this time is that we have implemented an online payment system during the pandemic, and we will be launching an enhanced service on Monday, August 3rd. It's called Prompt Pay, and that will allow tenants to continue making their payments and their protective order payments into the court registry if they have an order in the case to do so. So those are just some of the things that we've been able to do as far as triaging the cases and sending out the remote notices. We've actually been capturing a lot of data and working with the landlords quite extensively for several weeks now to aid us in obtaining information, email addresses, and telephone numbers so that we can include and schedule as many cases as possible. Right now, we're scheduling anywhere from 20 cases per day. We expect that there'll be some adjustments as we address any technical challenges and capacity. Right now, all hearings are only being scheduled in one courtroom, and that's courtroom B109. At some point, as we resume operations and we go to the next phase, then we will open up courtroom B53. But right now, that courtroom is being used for other civil matters. And I'll pause right here to find out if there are any questions. Joe, you're muted.
Steve?
You're good.
Okay, thank you. Thank you very much, Lachey. That was terrific. I have two quick follow-up questions. You mentioned 2,700 filings, I believe, since the start of the public health emergency, and some of them, I presume, have happened after the prohibition of such filings took effect. And we're wondering what you are and can do about those filings. And then the second question is that, of course, the council didn't ban hearings at the court, nor could they. That would be a separation of powers issue. But it would be helpful for our audience to know what like categories of cases the hearings are starting up. I take it it's not evictions generally, it's more specific categories of the cases. But start out with unlawful filings.
So from the court's perspective, let's see, what is my politically correct response? So the clerk's office, so recognize that I am not an attorney and I take direction. The clerk's office takes direction from me and based on the decisions made by the director's office and both the presiding judge and deputy presiding judge regarding whether or not we should accept or reject filings. And we have not been directed to reject any filings. So if filings have been submitted despite any moratoriums that state or imply otherwise, we only reject filings based on technical issues. For example, if something were wrong with the case caption or it were not notarized or paid for example, then there are only very specific reasons why we would not accept. I neglected to mention earlier that for all the cases that have been filed during the moratorium, which is somewhere between 1,000 and 1,200 cases during the moratorium, to date, those cases that have been filed after the time period when legislation went into place to say that cases should not be initiated, the court has issued show cause orders. We did start processing those last week and they have started going out. And I suspect that it will take us a couple of weeks to get through all of them. But that order specifically directs parties to show reason why the case should not be dismissed. And the presiding judge and deputy presiding judge will determine based on responses whether or not to dismiss that case. If a response is not received within 30 days, then then those cases will be dismissed without further action from the court. And all of that is explicitly stated in the show cause orders that began going out last week.
Could I jump in, Joel, just to say something?
Yes, please.
I was just going to say the number of cases, I mean, I think those of us who advocate on behalf of tenants are concerned that the court is continuing to accept, the complaints even now. But I will say the number of cases, I have looked at, these numbers just through looking at the publicly available dockets. It has only been a few dozen cases filed since May 13th, when the local filing ban went into effect. And to be frank with you, those are cases, I've looked at all of them individually. They are cases filed by either landlords who don't have attorneys, and I think probably don't know, or landlords' attorneys who don't usually practice in landlord-tenant court in DC and probably also don't know. And so, I mean, Eddie's not even a good example because Eddie is so careful and scrupulous as a landlord's attorney. But there are some landlord's attorneys who are not always as careful. But all of the regular folks who practice in landlord-tenant court, they are not filing. And so even though the court is not rejecting new filings, you know, and we would take a different position, I think it's just important to know that we have not seen a huge number of filings since May 13th by any means.
We at
We see
OTA,
11 complaints.
11 complaints. Got it.
Only 11 for the month of June. We have seen a significant reduction in the number of complaints, just generally speaking, compared to how busy we normally are. There's been a drastic reduction, but there were 11 filed in the month of June, I believe like 78 in the month of May. So there has not, to Beth's point, been the numbers that we've seen traditionally.
Got it. And just to remind the audience, we're talking now specifically about filings since the council banned such filings, but the council banned such filings dating back to the start of the public health emergency. And that is the constitutional question that Beth and Eddie broached a little bit earlier on. So just to be clear about what that question is about. The OTA is also getting, first, secondhand complaints about illegal evictions. And I wonder if our three attorneys, Cristobal, you're welcome to join in too. I was thinking of practitioners, including Jan at OAG. But what can you tell us about the incidence of illegal evictions, and what do tenants need to know about illegal evictions and what to do if it happens to you? And let's start with Jen from the OAG's perspective, if that's okay.
Sure. So we have, and this is owing to a robust tenant advocate community, we've received a lot of referrals related to wrongful eviction. We imagine that there are many more out there, as Beth was saying earlier, because people are afraid to come forward, especially if they're afraid of being deported. Out of the complaints that we received, which were about 100, as we mentioned earlier, 180 since April 24th, when we were logging those, there were 40 cease and desist letters sent out for a number of different reasons. Half of those were sent out at least for wrongful eviction situations. In one instance, a building owner posted a sign in Spanish on the building saying, pay rent or move. And there's some questions in the chat about that very issue. Landlords can say to individual tenants that they owe a certain amount of rent, but they cannot say pay or move, because a tenant looking at that notice will be afraid and want to move. That notice has been taken down since, but in terms of what tenants should know, even when there's not a pandemic, evictions without court process are always illegal. So they cannot happen, and that's doubly wrong in the pandemic because the COVID legislation specifically prohibits that. So they should absolutely report any issues with wrongful eviction to the different services that have been mentioned in chat. We put OAG's helpline. We want to know about that. We have subpoena power, so we have the authority to issue subpoenas to collect information about the pattern and practice of housing providers in this regard, and we're happy to forge forward with that and make sure people are protected. No one should be subjected to that additional stressor during a time that's already stressful.
Great. Does anybody else want to chime in on illegal evictions?
Yeah, if I could just say two things real quick. I mean, first of all, I really want to emphasize what Jen just said, and everybody tuning in, if you are a tenant, if you work with tenants, if you work in the community, please do everything you can to get the word out, because tenants are scared. Landlords are frustrated. And so we are seeing more and more of this kind of behavior. And I just want to be clear, this can include things like the landlord says, I want you to leave. The tenant says, I'm not going to leave. And the landlord says, well, I'm going to turn off the hot water. or someone who contacted our office, it was, well, I want to rent to somebody else. I'm just going to start showing the unit and I'll bring in tenants whenever I want to so they can come see it. And that is harassment. It is intended to try to scare tenants from standing on their rights. It is wrong. And so please, reach out to the Office of the Attorney General, reach out to the Legal Service Provider Network with the phone number I put in the chat so that we can help those tenants and try to make sure that folks are able to stay and fight for their units and try to stay in their units.
So in terms of this, I would say that OTA has the document up on our website, which is the OTA COVID-19 Tenants' Rights and Resources document. And I would encourage tenants in the district to read that. I mean, the more you know about your rights, the more you can make them actionable. And I think in this particular moment, especially the public health emergency laws that have come out, it's particularly important for tenants to be aware of that.
And Cristobal, that's great. I'll add the Tenant Bill of Rights, which sort of has the whole what's has to be done that Beth reviewed about prerequisites, legal requirements in order to be lawfully evicted in the district. So those two documents, please do read and become familiar with, and use the hotlines like Beth's, and give us a call if you have questions, any questions about those rights. Steve has sent me a question having to do with what if one owed rent, I suppose, prior to the public health emergency. And I'll just frame that as under the rental payment plan requirements. Any tenants, upon demonstrating to the landlord a hardship paying the rent during the emergency, and then agreeing in writing to a rent payment plan, is going to be entitled under that law to work something out with the landlord. But does anybody want to address that? Again, it's about where a tenant has owed rent has been in arrears prior to the start of the emergency. Anybody want to tackle that one?
I think, and I suspect Beth will have more to add to this as well, and I welcome that. But the amounts that are subject to the repayment plan provision are the amounts that fell due during the public health emergency period. So for prior amounts, that does hearken the question that you asked earlier, Joel, about disabilities. If a tenant has a disability and there are accommodations that could be requested under the Fair Housing Act and Human Rights Act, then that may be a way of addressing debt that accrued prior to the public health emergency in that payment plan.
So Jennifer, you'd agree that to the extent the tenants can make some payments, pay off the arrears that accrued prior, and then you're in a position to have the right to rent payment plan?
I think, again, I want to hear Beth's thought on this as well, but okay. I think the right to a repayment agreement exists regardless, but it relates to the rent that came due during the public health emergency.
Yeah, and I think really this is about avoiding an eviction on that first day that the eviction can be the action can be filed after the public health emergency gets lifted. So we're talking it gets into legal advice in particular situations, but Beth and Eddie, do you want to add anything to this discussion?
Sure. Jen is correct. I mean, under the COVID legislation from the DC Council, the payment plan obligation or mandate only covers monies that fell delinquent after March 11th. However, oftentimes people may owe money from before that period, and the question becomes what to do. I know I have advised many of my clients already to include the pre-COVID outstanding debts in the payment plan, because I believe it's a much more efficient way, both from a practical standpoint, a procedural standpoint, and a legal standpoint. Because if I do a payment plan for somebody who owes May, June, and July, as I'm required by law, but they owe me January, February, and March, and I file a court case based on those 3 months, you're basically attempting to file half a court case and maybe get half a judgment, and they may be current on the payment plan, but not current on the other. And I think that's, if you try to do that from all of those standpoints, it's just nothing more than the Titanic waiting to sink, because it's going to create a lot of problems, again, practically, procedurally, and legally when you get to court, because it's essentially, in its essence, it's half a court case and half a judgment, which I don't know that you're allowed to get. So I've advised people it's much more advantageous to the landlord as well as the tenant that if you're going to do a mandated payment plan, it might be worth considering taking the total amount owed and including it in that payment plan to make it, in the event it goes past the payment plan and into the court realm, that it comes in cleaner and more efficiently when it goes in while it's there, and hopefully when it comes out at the end of the day.
Great. Beth, did you want to add something to that?
Yeah, the only thing I was going to add, two things. I mean, first of all, I will just say, I think the best advice, if you're a tenant, always is to pay your rent if you can, with the kind of exception that if you have poor housing conditions, you have a right to withhold your rent. But I would always tell you as a tenant, hold on to that money, because at some point you will be in court and a judge or jury is going to have to decide, or you're going to have to work out with your landlord whether you pay it back. And so you want to be ready for that moment when maybe you do have to pay at least some of that money back. But nothing about the pandemic changes the fact that tenants also can raise legal defenses when they're sued for rent. So you can come to court and say, the landlord says I owe $6,000, but they didn't credit some of my payments. Or I live in subsidized housing, my rent is supposed to be based on my income, and I don't think they calculated it right. I live in rent control housing, and I think this last rent increase was illegal because they didn't give me proper notice. Or what is true for many tenants in DC, I have poor housing conditions, and I told my landlord about it, and they didn't fix it, and so I don't think I should have to pay all of that money. And nothing about the pandemic changes that. As rights that tenants have to raise if they want to with their landlords and through the court process, or even now, if you were talking to your landlord about paying back some money that you owe and whether you should have to pay all of it back.
Wonderful. Okay. Thanks, everybody. So we want to pivot now and talk policy. The category of questions, this is going to go to the effectiveness of the emergency measures so far. What improvements need to be made to those existing measures that the council has put in place? And then what further policy actions that have not happened yet need to happen? And I'm mindful of what was suggested earlier about what Beth said about a delay of the problem versus a solution to the problem, and to what extent we really need the federal government to step in order to finance the needs of DC tenants, because if you think that the DC government can't handle that alone, or can they? But let's start out with the existing measures and what needs to be improved. And why don't we start with Beth on that one?
So I will give a couple ideas. One thing, as we've already talked about, is evictions are on hold during the public health emergency, but no longer, whereas new eviction cases can't be filed for an additional 60 days. And as has already been mentioned, the Office of the Tenant Advocate, I believe, supports this as well, extending the period when evictions cannot happen to go at least 60 days beyond the public health emergency, to give tenants a chance to get rental assistance, to be able to stay in their homes, hopefully, and have time for that. I also think in general, it's just important to try to keep all these protections in place, even as the public health emergency goes on for a longer period of time, because there is going to continue to be pushback at the council to cut back on some of these rights, I believe and predict. And landlords already have asked for certain things to be changed. And then the tenant payment plan, I know I have talked to the Office of the Tenant Advocate about this issue as well, that we think more guidance on that would be helpful. I mentioned in the chat box in response to a question, there's a complaint process through the rent administrator and the Office of Administrative Hearings if a tenant is denied a payment plan, but we want to make sure it's clear that if a landlord offers illegal terms or just refuses to respond, that those actions can be challenged as well. So it'd be helpful if the law was even clearer about that. But I think mostly what the council actually needs to do is the financial assistance piece. We are all hoping the federal government will be passing more relief, including potentially a very large rental assistance fund. We, of course, all hope that DC will be treated as a state and not a city in any calculation of the money that comes. Because as I think many folks know, the DC budget process, which is being finalized right now, is just really tough this year because there's less revenue coming in. And so the council is facing a lot of pressure. I also think the council is going to have to look at this all again in the fall. And if folks are concerned about these issues, they should be advocating with their council members to consider tax increases to get more revenue so that we will have more money available for these programs.
Great. Eddie, do you want to pick up from there?
I don't know how much I have to add as to what Beth had just indicated, but the district is facing a monumental task here because the revenue coming into the city as a result of this pandemic is going to decrease substantially the amount of money that's coming in, and they have to make up that money in order to not only balance the budget, but also to provide funding to programs that would help landlords and tenants with regard to subsidies that might be able to be given to tenants and landlords, provided that they could document or demonstrate a la the payment plan that they've been impacted by COVID. And I don't know, there's also a lot of talk that an effort to increase the amount of funding that the city provides to ERAP every year, doubling that amount of money. And we should have a little bit more information after this weekend, depending on what happens with the CARES Act. There's talk that there's going to be stimulus money that's proposed in these packages. I know the House of Representatives has proposed and passed the HEROES Act, which is basically another stimulus bill that totals about $3 trillion. A lot of that money going to local municipalities and states with regard for financial aid for those people. Whatever the final bill comes out, nobody knows yet, but we'll have an idea next week. And whatever the new assuming a new stimulus bill is passed by the federal government, that bill may include money for local jurisdictions with regard to helping money coming into the city budget here that may then be able to be redistributed in a way to provide some sort of additional subsidies to both tenants and landlords regarding the situation that we have.
Great, thank you very much, Eddie. I'm going to ask Cristobal if he has anything, and then I'm going to ask Jen if something needs to be done to enhance OAG's role or enforcement authority, anything along those lines. And Lachey, I'd also like you to speak to whether anything, is there anything the council can do to enhance the court as hopefully a part of the solution to the problem, anything to make the court's lives easier during this period, etc. But first, Cristobal, do you have anything to add to Beth and Eddie?
Yeah, thanks. So, we all understand that this is a dynamic situation. The curve goes up and it goes down. The public health emergency has been extended. So at the Office of the Tenant Advocate, we've been working hard to identify policy gaps in the public health emergency legislation. As Beth already mentioned, the tenant payment plan eligibility requirements aren't very clear in the law. That's one thing that we've identified. And another area is, let's say, break lease scenarios. Washington, D.C. is a unique city, and people move here either to go to school or for a particular job, and then this happens. So these are other policy gap areas that we've been trying to identify with our partners and with the attorney advisors in our legal section. And we're hard at work with that. Thanks,
Cristobal. Jennifer.
In addition to what my colleagues have already said, I think there are two areas that could be improved. One is the subpoena power of the Attorney General's office could be stated as explicitly as possible so that we don't encounter issues with contests to that subpoena power and the broadness of that authority. Right now we do have that authority, but it is better if it's more explicitly stated. And then separately, we have encountered that the complaints relating to the payment plan provisions can go to DHC or should go to DHCD. But DHCD needs to be supported to add the resources for them to field those complaints, because the infrastructure was not created for them before that ended up coming into play. So that is really important to make sure before creating a requirement and a complaint process that the people who are going to be complained to are equipped to handle those complaints.
Thank you. Lachey, anything the council can do for you and the court?
The first two things that come to mind is just the continued collaboration that we have with all of the partners that are here on the call with me. So the partnership that we have with Beth's organization, with the Landlord Tenant Resource Center, Office of Tenant Advocacy, Legal Services for the Elderly, and many of the practitioners that I've been working with over the past 5 to 6 years. If we could just have those continued interactions, but also if those same organizations and the tenants, if they're on the call, I would encourage people to reach out to the clerk's office if you have questions. The staff is not able to provide legal advice, but we are able to provide contact information so that they can ensure that their rights as tenants are protected. And then additionally, if everyone would refer tenants when they need to file something, whether they're a tenant or a self-represented landlord, if everyone would use the Case File Express website to submit their filings, that really helps us out a lot. It's a very manual and intensive process, and will become increasingly difficult as we ramp back up to normal operations if people are not using the electronic filing method for us to keep up with the volume that we anticipate will resume as soon as these moratoriums are lifted. I also want to share, in case people don't know, that Case File Express has posted a number of very well done videos to show court participants, how to submit filings electronically. And then the other thing that I would say, from a policy perspective, no, I don't have any recommendations because my role is more about administratively supporting the policies that are in place and making sure that our rules and business processes internally support that based on the direction given from the presiding judge. But outside of that, I don't have any specific requests other than what has already been shared and what I just shared.
Terrific.
Thank you.
I love the collaboration message. Thank you, Lachey. That's terrific. And thank you, everybody. I've got a ton more questions, but we're approaching 2:30. And I'm wondering from Stephen whether we can take a couple of further questions from the chat box.
Yeah, most definitely. And I want to thank everyone for sharing their information in the chat box. So definitely review the chat box. There's a lot of information out there. And thank you again for sharing. It's definitely a great community sense to be able to put information out there and have that conversation throughout the panel. I'll get to a couple of questions and we'll end by 2:35. I'll try to sum up some of them. At the beginning of the presentation, there was a lot of concern of harassment from the landlord due to tenants getting sick and not being able to pay rent or not being able to pay rent at all because of COVID-19. Would you guys instruct, or Joe, please assign someone to answer how they would advocate for tenants who are being harassed by their landlord?
Well, let me turn to Jennifer first to see if there's an OAG role, and then we'll turn to the others to see if they have anything to add. Jennifer, do you want to tackle that one?
Yeah, we want to hear about situations where there is a pattern and practice of the housing provider of engaging in behaviors that are illegal and that type of harassment could be illegal. That would take a case-by-case analysis. But for instance, in the case of posting pay your rent or leave in Spanish, that was a case that we took on. And I'm going to repeat our information in the chat box so that you can put those cases over to us. Joel, was I on mute?
No,
part of that?
I did something. So Steve,
That's okay.
Steve did something. I'm not sure which one of us. So I didn't hear the last your closing sentence. But
You're the eyes and ears in the community. We want to. There is a tremendous amount of attendees on this presentation, and we want to make sure that you share this information with the community. And you're the eyes and ears. If you hear of something, say something for sure. And I'm putting OAG's information to process complaints in the chat box again, so it's fresh.
okay, thank you, Jennifer. That was terrific. Anybody else want to add to the issue on harassment in particular? And if not, and Steve, I do have a question, a follow-up question on rent payment plans. If you want to take a further one it's actually from the previous questions that we received, but if you want to take another one from this audience that they're asking now, that's fine.
I think your question would be suitable. There have been a lot of questions on rent payment plans, which gives me the idea that we may want to have a separate session on that.
Yes. Yes.
But I think your question will cover everyone's concern in regards to rent payment plan.
Okay, and the question, I don't have, so I'm paraphrasing the question, but it essentially goes to this situation where the landlord and the tenant simply can't come to terms on the rental payment plan. I believe the law is, and somebody might have a different view of the law covers the duration of when the rental payment plan must be offered, the duration of the repayment itself, which is a year, and the fact that a tenant can file a complaint, as Beth said, on the basis of a denial of an application. But what does that really mean? I think that the answer to the question is if the landlord and the tenant cannot come to terms, the law is silent. I think is relatively silent. There are some things that the law might inform, and I want to get that perspective. But it also goes to the possible need, one of the clarifications in policy-wise that Cristobal mentioned, which is absent a standard, do we need a standard? Should there be a good faith reasonableness basis for a landlord not being able to come to terms with the tenant? Are these situations happening from Eddie's perspective? So that's a big question, and any aspect of that anybody wants to respond. And since I mentioned Eddie's name, Eddie, do you want to tackle that first?
Stephen, can you please repeat that? I didn't catch the last part of that. What you were asking?
Okay, so it's Joel.
I'm sorry, Joel.
Yeah, no, that's okay. So the last part of it was, is there a policy problem here, a gap in the law? So if the landlord and the tenant can't come to terms and the answer is not to be found in the law, should there be that gap filled in the law?
I do think that portion of the law, as I indicated before, like many other portions, need to be clarified because there is a lot of parts of both the federal and DC legislation, these emergency pieces of legislation that A, are unclear, B, create more questions than they resolve, and that's one of those as well, because it's not entirely clear. It mandates the payment plan having to be notice being issued to everybody and somebody to get an application and to be able to demonstrate or document indirectly or directly that they've been impacted by COVID financially. And if that's the case, then a payment plan needs to be given to the tenant. But if the parties can't come to an agreement, it doesn't really say what happens there. I don't know. I mean, I would suspect that if a landlord was only offering a payment plan for 3 months instead of the required 12, that if that landlord tried to file a case, that they would have an issue because they're obligated to give at least 12 months. The flip side of that coin is that if a tenant does not feel, because maybe they're a restaurant worker right now and the restaurant industry is not fully back to work, that they're not sure. I had a beauty salon owner call me, who's a tenant, and ask this question. I'm uncomfortable about signing a payment plan now because I don't know whether I can pay my debt in 12 months. I might need more time. Well, the law indicates 12 months, but is not entirely clear, again, on what happens if an agreement can't be reached for one reason or the other. And I think that needs to be addressed at some point. It's probably much more efficient to have that addressed in terms of legislation than waiting for all of these issues months from now to appear in court on an already clogged up docket to try to get them resolved at that point, which is going to take much longer and be more costly for all parties involved.
Eddie, do you think that a judge in their judiciousness would impose a reasonableness standard implicitly and ask the parties, what the heck happened? Why couldn't you come to terms? Or is that something they just wouldn't go to?
I think most judges would do that because in small claims court and landlord tenant court, these branches are much more subjective and less subjective than the civil branch of the court. And much of the information that goes back and forth in these courtrooms is done on proffers, unlike people under oath and notarized affidavits, etc. And I believe that the judges in both those branches are allowed to relax the rules of evidence as they see fit in an effort to obtain substantial justice, is I think the phrase that's used by the judges. And I believe rightly so. There's, many of the judges over the years in landlord tenant court implore a very practical approach to these things, which is a good thing to do a lot of times in this branch of the court, because if it leads to resolution of the issue to the satisfaction of both parties, then I think it's a good thing. And I would imagine that when these cases start coming to court and all of these issues come up, if there was a breakdown with the out-of-court payment plan, and I think Beth would agree, I can see many judges saying, look, why don't we pass the case and you two go outside and see if you can reach a payment plan now that's acceptable to both of you, because that's just how that branch works. It's a little bit more subjective as opposed to the civil division and other branches of the court.
Wonderful. Okay, thank you. And Beth, or does anybody want to add to that?
If I can just add two things with advance apologies to Eddie, who is a good friend. But I just want to be clear that landlords, what they're seeking at the council in terms of clarification on the payment plans is largely to cut back tenant rights. And so, but I think we can all agree there are ways that the law could be clearer. And I will say, I agree, the landlord tenant branch does a kind of yeoman's job of trying to ensure just outcomes. That is very difficult to do with 200 cases a day in normal times. And I think we always have to remember, those of us who are lawyers and work in the legal system, that the court system and legal system is designed for lawyers, not real people. And that's across all parts of the court and all parts of the legal system. So, only 10% of tenants get access to a lawyer in normal times, and that's a concern. But I think the good news right now is the court has had to slow down operations. Things, and as Eddie said, I think they'll have to be slower for a long time. And the good news is that gives judges more time to be careful and not feel rushed and be able to be fair to both parties. And that's certainly what, we hope to continue to see always, but as these issues come before the court. And so, we legal service providers are out there to try to help as many tenants as possible so that they can navigate these legal systems that, are very hard, I think, for folks who are not lawyers to deal with. And that's despite the best efforts by the court. But the bottom line is that courts are designed with complex processes and complex laws that can be very hard for individuals who are not lawyers to understand and navigate their way through.
Okay, terrific. Well, I think we're going to have to leave it there. I'm going to wrap up by saying we want to thank our panelists for an excellent, robust discussion. You covered a lot of material in a very short period of time. We'll have to do this again. I also want to thank the participants. Steve told me there's well over 200 of you. Thank you so much for joining. I think Lachey said it best that it's really important that everybody stay together and as collaborative as possible. And that will certainly help us find solutions to these very big problems. I also want to thank Chief Tenant Advocate Johanna Shreve and Chief Deputy Attorney General Jason Downs, and also the Attorney General Carl Racine for agreeing to make this a joint forum. So we thank all of you for joining us and for your questions. Please stay safe, stay in touch with the OTA and with each other, and we hope to see you soon. Steve, I think that about does it. Do you have anything else?
So just there is a of the survey for this event in the chat box. Please fill it out. I'll also email it to everyone who is attended. What I'll try to do is go through the chat box and get all the essential information that was put in by the panelists and the attendees and have that breakdown when I email the survey. And if anything comes up, questions that weren't answered, I'll try to reach out to you before I go on vacation at the end of this week. And if anything comes up, you have my contact information. I'll put it in the chat as well, and you can contact me. And again, thank you for everyone, and thank you for joining us.
Thanks, everybody.
Joel, you did a great job.
Thank you, Beth. You did a great job as always. Everybody was great. Thank you. Thank you, Lachey. Thank you, Eddie. Thank you, Cristobal. Thank you, Jennifer. Thank you, Steve.
This was great. Thank you all.
Sean.
Bye, guys.
Thank you.
Have a good day.
Thanks. Talk later.